wisdom from me. It's mostly because I want to contextualize things that you may know, things that you may not know when it comes to IP, which you might have heard in isolation, but I will try to tell them to you as part of a nice story, because IP is something that you are going to see all together in practice. There might be cases that you will have copyright and trademarks or copyright and patents together in the same case. So what I'm going to focus on is a more realistic way to see IP. And how we're going to structure the classes very quickly. The format will be the same in all three of them. Today we'll focus on copyright. I'll say some things about IP in general today, because there will be things that are going to be useful for us throughout these lectures. And then we're going to say some theory, which I will try to keep jurisdiction neutral, so that we're not going to discuss many laws, many provisions, things that you also wouldn't care that much about, because the good thing with IP is that even though every country has its own thing, it's a domestic system more or less, but to a big extent it's quite harmonized. And harmonized, I mean that most countries have managed to have a similar level of protection for IP, even though the protection is still domestic. So even when you hear all these things like the Berne Convention, the TRIPS Agreement, these have not made IP global. IP is still a purely domestic, a purely territorial concept. So the first part of each class will be a little bit of theory to make sure that we are on the same page. Then the second part, the last part of the class, will be like a case study I have chosen. For example, today, when it comes to copyright, we have agreed with Cheryl to talk a little bit about AI and AI generative works, and generally when you have a creator who is not human, which creates lots of issues, which started from, this very simple case is the monkey that took the selfie, and everyone didn't know how to handle this. Like, who is the creator of this? Who owns this copyright? Is there an infringement? And who claims the infringement? Is it the monkey that took the selfie? Is it possible that the monkey will have copyright? From more complex cases, like the one that we have ongoing now. Now we have the New York Times suing ChatGPT because they said that they stole all their material to create their database, both to train the AI and to use as information. And the New York Times saying, yes, but you use all this information that normally subscribers have to pay for to use in the New York Times. So is this copyright infringement? Is it not? Now, even though this is, I think, the most contemporary thing to discuss on copyright, this is what literally happens today. These cases are not even decided, they're all pending. Nonetheless, and trying to make this a little bit more interactive with you guys, when you know all the theory that I'm going to tell you and the brief facts of these cases, I would also like to hear your views. How would you decide this case? Do you think there is copyright, first of all? If there is copyright, who owns it? If there is copyright and you found who owns it, is there an infringement? Is there not an infringement? Is there some defense? For example, fair use, which is the most typical defense that we have in copyright. So what I'm going to show you is the way to go through all these steps to think of copyright as a math exercise, because practically this is what it is, and try to find arguments at each and every stage. Now, because everything will be, I will keep throwing information. You must have seen I talk fast. I say many things, and I want to make sure that you can follow me. I made a handout for you. This is what I do for my students as well. And I sent it now in the chat. I hope that you will get it soon. So I will share my screen as well, but I want to send it to you so that maybe you want to keep your notes there. At least my students find this pretty helpful, so you can do it as well. Let me know if you received it, because it looks like it's sent to me.
Yes, Prof. We can download it.
Perfect, perfect. So what I would recommend is that to keep your notes there. Today's handout would be slightly bigger, because I will start with a more general discussion about IP in general, arguments that are going to help us both in the copyright, the patent, and the trademark classes. Now, let me see if I can share my screen as well. Okay, I don't seem to be able to do it, but it's fine. If you have the handout, you don't really need to see it on my screen. So as you can see in the handout, the first couple pages in there have to do with IP in general. And from page 3 onwards, there are more copyright-related discussions, which is our focus today. Now, starting with some more general remarks when it comes to IP as a whole, as an umbrella. Some things that I would like you to keep in mind are this. First of all, what exactly is it that we are protecting here? Why do we have these laws? What exactly was this gap for which we created this whole IP, this elaborate and sophisticated IP system that we have in place today? So, breaking down IP into its two components, intellectual and property. Now, property, I think, is something we're more or less familiar with. What is property is a legal right over a thing, right? A legal right over a thing that gives you some exclusive right, exclusivity. Property is all about exclusivity. What is exclusivity? Exactly what the name suggests. You can exclude everyone else from using this thing. It's literally exclusivity is just that. At the same time, exclusivity, exclusive ownership means that I can do everything I want with my thing. I can use it, I can sell it, I can dispose of it, I can rent it, I can license it, I can alienate myself from it. I can do everything I want because I own it, because I have this exclusive right. Now, when it comes to property, I have put in your handout one article from the Universal Declaration of Human Rights, not really because it's so relevant here, but to see how big a thing property has become. So, under this provision, we can read, I quote, everyone has the right to own property alone, as well as in an association with others. No one shall be arbitrarily deprived of his property. So property has become such a thing that we consider it a human right. If you think about it, the fact that property is a human right nowadays is huge. Now, could someone go so far to argue that intellectual property is a human right? Probably not. Which is why I think we need to address a little bit the first part of the equation, the first part of the component. So we know more or less with intellectual property, we protect intangibles. We protect something that we cannot see. What that would be? What is it exactly that we're trying to protect here? Now, with IP, we protect what we call very simply the intellectual capital. What is intellectual capital? Because it sounds a bit too fancy. It cannot be that difficult. Think of a company, guys. Whatever company. You see, I have used Starbucks to make an argument a little bit below, but think of any company you might have in mind. So what we're protecting, what this intellectual capital very simply means, it means all the knowledge that exists inside this company. And by knowledge, I mean all the know-how, everything the employees knows, all the information in the company, all the designs, all the copyrights, all the trademarks, all the patents, everything that exists inside the company is its intellectual capital. Now, the problem is that if all this intellectual capital exists in theory, we cannot very easily protect it. In order to protect this intellectual capital, we have somehow to capture it, to document it. So, the moment we document this knowledge, this intellectual capital, we essentially create our subject matter here. We create intellectual assets. We create intellectual property. And most importantly for our purposes, when we document this capital, when we capture this capital, we create copyrights, we create trademarks, and we create patents. And some more secondary rights that have to do a lot with our three main ones, like domain names, trade secrets, geographical indications. But all of them, to a large extent, are protected through the vehicle of your main three IPs: copyrights, patents, and trademarks. Now, the focus of IP, without having any intention to go through the history and that stuff, and this is not my purpose here, but have in mind that with IP, we started with a very clear intention. We started, when we started, ancient times, but when we started, the goal was very simple. We want to protect the good, we want to protect the asset from being copied, especially after printing press and typers and all that stuff were invented, so copying became so much easier. And we needed to put a stop to this, which is why we needed a law to protect from this copying. This is how IP started becoming a thing. Now, if you ask me, is this how IP works today? 100% no. This is not the focus of IP anymore. IP now is all about money. IP is all about this commodification, this commercialization of ideas. This is the focus now on IP. We don't care so much to protect the creator that we wanted back in the day. And by creator, I mean the author when it comes to copyright, or the inventor when it comes to patents, or the trademark owner when it comes to trademarks. We don't really want to protect him from copying anymore. This is not the objective. The objective is to give him an exclusive right, exclusive meaning monopoly, a very strong monopoly, over his idea, which he can commercialize, which is why IP has become a commodity in itself. You read on the news about Starbucks, let's say that we're talking here. Starbucks as a brand, which is another term that is should be very familiar to IP people, is worth $12 million. How is it possible that something you cannot even see, something that is intangible, is worth so much money? It's exactly because Starbucks and all these companies are investing so much money in order to leverage their intellectual property. And how they do that? Going to the more commercial side of it. And you could help me actually understand how IP got so global, because I spoiled to you from the beginning of this lecture. IP is a domestic concept, is a territorial concept. We don't really have a universal protection of IP. We have international laws that try to harmonize IP protection. And harmonize meaning there are some minimum standards of IP protection that exist for all these countries that are signatories to whatever, the Berne Convention, the TRIPS Agreement. But still, we don't have a uniform IP law internationally. Everything is territorial. Yes, but IP as a concept commercially is not territorial. IP is very global, and I think Starbucks is a really good example in this regard. So my question to you guys is, when you hear Starbucks, when you see Starbucks, what comes to your mind? It should ring some bells. What instinctively, what do you think when you hear Starbucks? Regardless of where you are.
Famous trademark.
Trademark. Yes, the mermaid one, I assume you say. Anything else other than the trademark? Anything inside? Regardless of where you are in the world, what would you see inside the Starbucks?
Class, if you want to respond, please respond.
If not, I don't mind, guys. You don't have to. I am a little bit interactive like that, but no pressure. I can take over if there is no, there is no input. Okay, so let me tell you what I have in mind. So the moment you enter Starbucks, no matter if I am in Athens, in Greece, where I'm from, no matter if I am in Delhi, no matter if I am in Dubai, in Jakarta, it doesn't matter. Anywhere I go, it's very possible for me to choose to go to Starbucks. Why? Because I know what I'm going to see there. Other than the trademark, I'm going to see a very peaceful environment, full of people potentially from different countries, countries. I will see coffee that I recognize, coffee with all weird Italian names. I will see lighting, which is not very strong, not very low. I can also go to work there. I can hear American jazz music playing. So what are all these things that in itself, they look a little bit immaterial? Altogether, however, they tell you a story. They tell you this ecosystem that Starbucks wants to create. Starbucks wants its customer to go there and feel comfort, visual comfort, oral comfort. They want their customers to feel comfortable. So, knowing what to expect and creating this reputation for yourself is essentially the reason why we go to Starbucks and we don't complain when we have to pay $6 and $7 for a cup of coffee. Because Starbucks very efficiently has managed to leverage this IP. And when I say IP, don't think that Starbucks is all about the mermaid trademark. Starbucks has also many copyrights. Starbucks owns a whole music label. Starbucks has at least 10 patents. Patents from the sleeve that you hold, your coffee, patent. Not anymore, it has elapsed, but it used to be like a valid patent. Or even the part here, when you drink, patent. So Starbucks plays in so many different fields of IP. So the moment that you pay so much for your coffee, and really you're not paying so much for your beverage, you pay most for the way that Starbucks has decided to leverage on its intellectual property. It has to pay its lawyers to register the IP rights, to litigate, to arbitrate the disputes. So this is what you're paying for. Does it make sense? In my opinion, yes. In others' opinion, no. Obviously, who is so stupid to pay $7 for a cup of coffee? But this is a personal and very willful choice that you are making. Clear, guys, so far? I take that as a yes. Now, the problem that we have, even though IP has managed to become global, is that the laws are not global. So, yes, you will see in the handout I have put things like the Berne Convention, which is on copyright, the Paris Convention, which is on what we call industrial property, so trademarks and patents, basically, or the TRIPS agreement that I'm sure all of you are aware. These things do not create IP laws. These things are there only to make sure that the parties that are signatories to these conventions or members of the WTO in the TRIPS agreement scenario all afford or give the same minimum standards of protection when it comes to IP. Why is that? Obviously, because I know that me, as a Greek investor, when I go to Indonesia to make an investment, I need to make sure that my IP will not be stolen the moment that I land in Indonesia. So the fact that both Indonesia and Greece are parts of the WTO, of the World Trade Organization, so they are signatories to the TRIPS agreement, very simply means that I know that I will be much more secure to come to Indonesia and invest because I know that my IP will not be stolen the moment that I reach. This is why these IP agreements, these IP conventions have become so successful, not because they are ambitious. On the contrary, if you read these conventions, they are very modest in its application. But this is their purpose. They don't want to be ambitious. They want to attract as many members as possible. How do you do that? By making sure that you safeguard, that you guarantee a series of minimum protections. This is what these conventions do. Either Berne Convention when it comes to copyright, Paris Convention when it comes to trademarks and patents, or the TRIPS agreement, which tries to regulate everything in one. Okay? So don't get confused when you see all these agreements, because they are very relevant, even for Indonesia, and think that they give a substantive IP protection. No, the protection will still be domestic. You still have to go to your own domestic law to see how its IP right is protected. But your domestic law has to be in line with the minimum standards that these international agreements prescribe. Okay? Now, when you talk about IP, no matter what IP, copyright, trademark, patent, we don't care yet. We talk mostly about three different things. One thing we discussed already. One thing is this monopoly, this exclusivity that the IP gives you. It's a very strong right if you think about it, especially when it comes to copyright, that is our subject matter for today. Copyright gives you essentially exclusivity, gives you a monopoly over how to use a word. If you use a word a certain way, only you can do that. This is how strong of a monopoly copyright is. This means that we have to be very careful as to where we give copyright, what should the limits to copyright be, importantly, what are the exceptions to copyright, fair use, and all that stuff. Because the monopoly, the exclusivity we give is so strong. But the first characteristic is that of exclusivity. Now, the second one is that exactly because IP is so strong legally, you understand it cannot last forever. There needs to be a limit, a temporal limit, a time limit as to how long the IP right is going to last. And the IP limit obviously has to do with the right that you have every time. For instance, let's say when it comes to patents, most jurisdiction will tell you a patent will last 20 years. Because we think that during these 20 years, the inventor can commercialize his idea as much as he wants. After the lapse of these 20 years, this idea should go to the public domain. This is why we have IP. We want to encourage people to create more and more and more and more. We will not encourage them if we give you a monopoly that lasts forever. We do, in fact, the exact opposite. If we give you an eternal protection, nobody else will feel inclined, nobody else will feel the motivation to create if they have a protection that is forever. Same is the case in copyright. Most jurisdictions will give you a protection on copyright for 60 years, 70 years after the death of the author, of the person who created the copyright. Same is the case with trademarks. Nonetheless, in trademarks, because the protection is not so strong as is with copyrights and patents, trademark will give you a protection for 10 years, but every 10 years you can renew it. So in trademarks, essentially you can be protected forever, but you have to prove that you are using your trademark. But if you prove that, which is pretty easy to prove, trademark can give you protection forever. But the reason is very simple, is because in trademarks, we don't give such strong of a protection as we give in copyrights or in patents. Okay, trademark, we only protect a word, but a word when it is related to a product. We protect the word Apple when this word is connected with a specific goods, which is electronic goods, mobiles, computers, things like that. Apple doesn't have a monopoly over the word Apple, only when it is used in connection with the product that Apple commercializes. Now, with all these three in mind, exclusivity, limited term of protection, and territorial character, this is the case for every IP, regardless of the IP you're talking about. Now, trying to classify them a little bit, I said already the main IP rights that we're going to discuss and that you will see in practice as well is copyright, trademarks, and patents. My main concern, because I think now we understood more or less what exactly we are protecting here, and all this discussion about intellectual capital and intellectual assets and all these things. My main question still is, why do we protect IP? What is the bigger goal that we're trying to achieve here? Or to put it a little bit more heavy in the theory, what are the justifications? What is the rationale for IP protection? This you must have heard, because I am aware you have some IP knowledge. Why do we protect IP? Does anyone want to help? Okay, let me take it. So, when we talk about justifications and we try to explain why is it that we want to protect IP, there are basically four different arguments that we bring forward, which are more convincing for some categories of IP, less convincing for others, but you will be the judge. On that, I will tell you all four of them. So, the first one, the simplest in my opinion, conceptually, is the natural rights arguments. So the natural rights arguments very simply tell you, you have to protect IP as of right. I deserve protection of my IP because I created it. Now, this sounds very simplistic, right? It cannot be that simple. You understand that. So when it comes to these natural rights theories, we have two sets of sub-arguments. You can refer to your handout for that because now things will get a little bit more difficult. Natural rights theories are divided into two parts. One is what we call the labor theory or the Lockean argument. Lockean means from John Locke, French Revolution, Enlightenment, blah, blah, blah. So what is the labor theory? Very simply, what is intellectual property? A is the product, is the byproduct of my work. So the mere fact that I worked so much to create something means that I should be protected for it, right? It only makes sense. This is one way that the natural rights theorists try to explain IP protection. Second way, but other side of the same coin, is this personality theory by Hegel. What did Hegel say? Very simply, still in the natural rights logic, I created the IP, so the product that I created, the book that I wrote, let's say, is an extension of my personality, is an extension of my persona. This is the reason in itself that is, as an extension of myself, the book that I wrote necessitates protection, necessitates IP protection, necessitates copyright in the example that I write a book. Now, are natural rights theories convincing? In my opinion, not really. But in the field of copyright, there is still a level playing field for natural rights theories. Because even instinctively, why shouldn't you protect someone for creating something? They did so much work for it, or they put a part of themselves for it. This is what the natural rights theories tell you. But when it comes to other IP rights, especially trademarks, and natural rights theories will not work because protecting trademarks is not really a natural right. You cannot justify it as such. Second line of arguments, a reward theory. What is the reward theory? Also very simple. I have to receive, because the society owes to me, I have to receive some reward for my services. A reward that is proportionate to the work that I've done. So, from a more social perspective, the society needs to reward me for all this effort that I did. Because I deserve a reward. Because I did good to society by writing my book. Let's say the same example. Also something that sounds very fair in principle. Is it bulletproof? Again, no. Because yes, I agree that you may deserve a reward for all this good work that you've done. But why would this reward has to be an IP? IP seems like too strong of a reward for you. You know, you can get money from society, from your government. You can get an award. You know, it doesn't mean that you need to get IP as your reward. It doesn't logically fall from that. Third line of argument, incentive theory. Now, I don't want IP as a reward anymore. I want IP as an incentive, as a motivation for me to continue producing and creating and writing more books. Because if I don't have IP, why would I continue then to write? What's in it for me? A very utilitarian way to see things, but a valid point if you think about it. I will feel much more secure to continue writing and writing and writing if I know that I will have some copyright protection over my books. Otherwise, it feels like a risk. you spend so much time to write a book while someone can copy this book in 5 minutes. So you feel a little disincentivized if you don't have any protection over your copyright. So what copyright does is gives you the incentive you want to keep creating more and more and more and more. In my opinion, the most compelling, the most convincing theory of those, yes, because IP will give you a security that for all this time, while the copyright lasts, you can keep creating. You have a good incentive because you're not scared that someone will steal your idea in the blink of an eye. So, natural rights theories, reward theory, incentive theory. Fourth theory has to do with something that we call, and now we move on to a little bit law and economics arguments. We move to something that is called the tragedy of the commons. Now, the tragedy of the commons, which again, spoiler alert, I don't agree with, is a theory that is also very simple to contextualize because it doesn't come even from IP. It comes from property law, from real property law. So the tragedy of commons says very simply, me and you guys, we live in the same land, okay? We are shepherds. So we have our animals, our cows, our sheep, and we all live in the same land. For the sake of argument, let's say this land is communal. It belongs to everyone, okay? It's a common land. So we all put our sheep, our cows, to eat from that grass. Now, the tragedy of commons says that because this land does not belong to anyone, it's a land that belongs to the commons, it's a communal land, there is no motivation for us to keep it well. So what will we do? Put all our animals to eat from this grass. And what will this do? Destroy the land. Taking this argument and trying to apply it in intellectual property now. The tragedy of commons says that it's not good to have things in public hands, in communal hands, while if this land was private, if I owned part of the land, Cheryl owned another part of the land, you guys owned another part of the land, we would have a very big motivation to keep the land in a good condition, to maintain the land. So, what is the solution to the tragedy of commons? Private ownership. Because if we had private ownership, everything would be amazing in this land. Same is the logic, according to this theory, for IP. If everything is common, then there is no progress. Then we will only go worse and worse and worse and worse until we have no land anymore. While if we have private ownership, which is IP, exclusive rights, this will help a lot because I will have lots of motivation if I have such a strong protection over my idea to keep creating, to keep disseminating my ideas, things like that. Now, does this theory sound convincing? Possibly. Can this theory apply in the field of IP? Difficult, in my opinion, as well. Because IP is not like real property. IP does not become worse through use. On the contrary, if you copy, IP becomes more and more and more, not less and less and less, like it would be in the real property scenario. So copying helps us having more resources. IP, intellectual property, does not deplete, it's not get destroyed through use, like land would be in the shepherd scenario. So even though the idea is convincing, I don't think that we can really apply it in the field of IP, but it is one of the main arguments justifying the protection of IP. These are the main lines of arguments. Okay, this is like a very heavy topic for you to like, but if someone wants to research, these are the main four justifications for IP protection that you are going to see. Again, regardless of the IP right that you have. So, we understood, I think now, what is it exactly that we're protecting here? And to an extent, I think we also understood why we protect it. Tell me if there is any question, because some general remarks, this is all I wanted to say before moving on with copyright. But tell me if something is not clear, guys, when it comes to the all-encompassing IP stuff.
Prof, pardon me,
Yes.
Prof. Maybe you can allow me to translate first to my students so they can understand maybe just a summary little. That's okay?
Of
So,
course, of course.
yeah. Okay, wait a second. Oke, gini, mahasiswa, adik-adik saya sekalian. Jadi gini, Prof. Nikolaos ini tadi ada 5 teori. Ada 5 teori. Tadi ada natural teori, ada personality teori dari Hegel, ada reward teori sama incentive teori sama tragedy of common. Ya. Kalau natural teori itu bahwa
I cannot hear you that well, but I don't know if it's just me.
ini sama seorang pencipta. Jadi ya. Yeah, sorry, Prof. My connection is interrupted.
Yes, that's why I don't know if you were audible to the students because I couldn't hear you. Like you were being interrupted in between.
Ya, tadi saya sudah sampai di reward theory, ya, bahwa seorang pencipta berhak atas sebuah reward, penghargaan dari masyarakat karena dia sudah menciptakan sesuatu yang berharga buat masyarakat. Terus tadi insentif teori itu di atas reward teori lagi. Jadi insentif itu lebih dari sekedar reward, tapi sesuatu yang membuat saya pasti dapat insentif tiap membuat buku atau saya pasti dapat sesuatu tiap saya membuat obat misalnya gitu, insentif teori ya. Terus tragedy of common tadi ini si profnya nggak setuju sama teori yang kelima ini yang terakhir ini karena kalau seandainya diumpamakan ke tanah ya, ke properti nyata yang terlihat ya, tanah itu kan properti nyata yang terlihat bahwa kalau tragedy of common ini karena tanah itu bukan milik siapapun jadi nggak ada yang mau menjaganya. Nah itu yang mau dilakukan ke haki, makanya Prof itu tidak setuju. Sampai sini paham para mahasiswa saya? Paham nggak? Ya, mudah-mudahan paham ya, biar kita bisa tetap lanjut ya. Oke, Prof. I already translate some your lecture to them.
Okay,
Please continue, Prof. Please proceed. Yeah.
Should I keep it simpler, Cheryl, or the level is good?
Yeah.
Do you want me to simplify it more?
Maybe you can simplify more, yeah.
Okay.
Yeah.
Okay. Then, guys, let's move to copyright. Now, when it comes to copyright, and what I would recommend you to do is to try to keep some specific points in mind and consider copyright or trademark or patent as an exercise, as a mathematical problem. This is what I will try to explain to you. This is how I see it, and this is how it has helped me a lot, even though you understood that I like my theory, but I prefer practice. But to go to practice, you need to know the theory very well. At least this is my approach. So, what exactly are we doing here in copyright? In copyright, it seems like it's the strongest IP. We protect ideas in a way. But also, based on what we said, you understand it's not possible to protect an idea. It has to be documented somehow. It has to be captured. You cannot protect something so abstract like an idea. So what is it exactly that we're protecting? We're protecting the expression of the idea. Only this we can protect. So if I go to a party and Cheryl is also in that party, and Cheryl tells me a joke, and I go and say this joke to other people in the party, did I really steal the copyright of Cheryl over the joke that she told me? Probably not, because this idea, the part that got people to laugh, the part of what was funny about this joke, was never Cheryl's copyright, because it's an idea, and we know we cannot copyright an idea because this would be a very excessive type of protection that nobody is okay with. No jurisdiction will go as far as to protect an idea. This, to be a little bit more fancy, is what we call the idea-expression dichotomy. Let me write it in the chat, because this is a little bit also more technical, but the idea is very simple. We cannot protect the mere fact that you came up with something. We can only protect through copyright the expression of this. Now, what can this expression be? We have two categories of expressions that we're protecting. Now, when I talk about expression in copyright language, we're going to call them works. So works can be of two types. First set of works, the main set, the one you should definitely keep in mind, authorial works. Second type of works, entrepreneurial works. I refer you back to the handout, guys, to understand what we're talking about, because I don't want you to get confused. These things are not complicated. So, if you go to page 3, where this information is, there is little information, but it will make more sense if you combine it with what I'm saying to you guys. So, the main distinction why we distinguish between authorial works and entrepreneurial works is because when it comes to authorial works, it's very clear for us to determine who is the author of these works. So, for instance, see under authorial works, you have literary works. What are literary works? Everything that is in written, basically. Books, songs, poems, novels, even slogans, advertising slogans, everything would fall under literary works. Literary works, think about it as an umbrella, as an open category where potentially you could fit everything. But it's very clear to pinpoint who the author is in literary works. Is literally the author, the person who wrote the book, the person who wrote the poem, the novel. Same is the case with the second category of authorial works, artistic works. Artistic works, I have added also an explanation, but you can understand what artistic works are. Sculptures, paintings, photographs, architectural works. All these things are considered artistic, and for our purposes, it's very clear to figure out who made them, who is the creator, who is the author. So, for all these things, there is protection when it comes to copyright. Literary works, artistic works, musical works. Musical works, you understand, is the tune of the song, the rhythm, the melody, the music. This is what we're protecting here. And last category of authorial works, dramatic works. Dramatic works, choreographies, TV shows, TV plays, all these are dramatic works. And this is what we're protecting here. So, authorial works are these ones, literary, artistic, musical, and dramatic. On the other hand, entrepreneurial works are just two, sound recordings and films. And why we distinguish between those two is, first reason, because when it comes to entrepreneurial work, so sound recordings and films, it's not very easy to understand who is the creator, who is the author of these things. In a sound recording, for example, you have so many people that are involved to make this sound recording. In a film, you have so many people that are involved to make this film. It's not so easy to understand who is the author as it is in an artistic work, a literary work, a musical work, in all authorial works. First difference is that. Second difference why we have this authorial entrepreneurial distinction is that when it comes to authorial works, we have an added level of difficulty. Difficulty because authorial works have to be original. When we talk about copyright, guys, we don't protect copyright like that in the air. We only protect copyright in a specific type of works, which are these works that I just told you, and copyright which is original. Your work has to be original. Now, this is a legal requirement, guys. But the good thing is that when we say original, we don't mean it so much like in the everyday language, because you might hear original and think that, oh, this is a very high standard. I have to create something new. No, originality doesn't mean that. Originality is not novelty that we will see next week in patents. Originality is a much lower standard, much lower threshold. And no matter the jurisdiction, because I'm trying to keep things as general as possible so that for you can apply this knowledge anywhere you are, no matter if you end up practicing in Indonesia or anywhere else in the world. But there are generally two approaches when it comes to originality, as to what is original. Does my work qualify as original? There are two standards that mostly follow. One is the UK standard, which is the low standard, and one is the US standard, which is a little bit higher. And this is what you will see again in the handout, the theory of it, the sweat of the brow doctrine, and the modicum of creativity doctrine. Now, this sounds again like Greek to you, I'm sure, but again, the logic is very simple. The first approach, the lower threshold when it comes to originality, says that very simply. When is a work original? When it comes from the author. So, the sweat of the brow doctrine very simply says originality means origination. If it comes from you, it's original. If you didn't steal it from anyone else, it's original. So, we need your own expression, yes, but it can be stupid. It doesn't have to be creative for it to be original. I just want it to come from you. This is the UK standard, or to be fancy, the sweat of the brow doctrine. Yes, we need you to try to make it. We need it to come from you. You shouldn't be stealing it from someone else, but that's all. Now, other jurisdictions, like predominantly the US, assert that this is not possible to have such a low standard of originality. We should need something more for that. What the something more could be? Some creativity. You need to be a little bit creative. Because imagine, I can see behind me my painting. My painting is from Van Gogh. If I take all the paintings from Van Gogh and put them in a book, is this enough for me to take copyright? Imagine, ironically, when Van Gogh wouldn't have copyright because he lived in a time where copyright did not exist. So imagine the original painter wouldn't have copyright, but I would, because I would put all the paintings of Van Gogh in a book, like a collage kind of thing. This sounds wrong. I will have copyright for something that even Van Gogh wouldn't have. So this is why in the US, they say we cannot keep the standard so low. We need something more than that. And this more, according to them, is some creative spark, some creativity. The author needs to try a little bit harder. He needs to be a little bit creative for us to consider this work original. Okay, but these are the two different approaches. No, doesn't mean that one is right and one is wrong, but you can make arguments based on both, depending on if your clients want to apply a lower threshold of originality and if your clients would like a higher standard. Okay, but no matter the case, we have understood so far you need to prove that you have an expression that is not just an idea you want to protect. You have to prove that you have one of the works that we discussed, either authorial or entrepreneurial, and you have to prove that your work is original. Clear so far, guys? Okay, I see some heads moving now, so I think now we're a little bit better. Now, after, what are we doing in this equation? Who owns this copyright? Because if I claim that my copyright is infringed, and infringed is, infringement means violation, but infringement we call it in copyright, in IP language. Obviously, the first thing that I have to prove is that I own this copyright. Only the owner can sue for copyright infringement. But who is the owner? Because especially in the things that I will discuss at the end of the class, about ChatGPT and all this generative AI, it's not so clear who the owner is. It's not so clear who can sue. But it has to be clear because only the owner can sue for copyright infringement and nobody else. So the rule of thumb, like the general rule that you follow if you don't know who the owner is, the general rule is that the author of the work is the first owner. Okay, so in the absence of proof to the contrary, the author of the work is the first owner, so the one that can sue for infringement. Who is the author? If you have a literary work, the actual author. If you have a artistic work, the artist. If you have a musical work, the composer of the song. Your domestic law will tell you who the author is. Usually we don't have to do some crazy legal constructions when it comes to that. But bear in mind that if your law does not help you, the rule of thumb is that the author of the work is the first owner as well. With one small exception. And the exception is when you are an employee. When you are an employee, guys, you understand, most of the times your employer will be the owner of the copyright, even if you create something as the employee. So if you have not agreed something to the contrary with your employer, and you create something, let's say you write a copyrighted work, or you make a patent, this will not belong to you. This will belong to your employer, unless you are smart enough to have a clause in your contract saying that whatever I created is mine. Now, in the context of employment, employment has to be clear relationship of employment, like hierarchy, subordination. For example, if Cheryl is part of the university, is a lecturer at the university. If Cheryl writes a paper, sadly, the copyright will not really be hers, will be the university's, because she's an employee. Now, I came to give you a guest lecture today. I'm not an employee of your university, at least in the strict sense. Yes, I do a lecture, I work, but not in under an employment relationship. So this is what I've written. If you go to your handout on page 4, this is what I've written as contract of service, which is what Cheryl does, and contract for service, which is what I do. Because Cheryl is an employee at the university, so the copyright will not go to her, it will go directly to the employer. And what I do as an independent contractor, a contract for service. Okay, so this distinction, contract of service, contract for service, is very simply that, an employment relationship, and my work and my copyright over, let's say, this video would belong still to me, while Cheryl's work would go to the university unless Cheryl has agreed to the contrary with her employer. Okay, so this is when it comes to authorship and ownership of copyright. And I repeat, it's extremely important, guys, to remember the rules of ownership, because you can only sue for copyright infringement if you are the owner of the copyright. Okay? Now, last part of the exercise. You have proven that you have copyright. You have made a work that is not just an idea, but is an expression. You have proven your work is original. Under whatever test we apply, sweat of the brow, modicum of creativity, doesn't matter. You have proven that you are the owner of the work. So you have every right to sue for infringement if another party violates your copyright. Now, when it comes to infringement, there are two types. There are two ways someone can infringe, someone can violate your copyright. One is the very straightforward way. I write a book and I see the next day that Cheryl is distributing copies of my book to you guys. The most straightforward violation of copyright, the most straightforward infringement scenario. Though not the only one. This would be direct primary infringement. But infringement is not necessarily only that. Infringement can also be a second scenario, secondary infringement. Secondary infringement means that, yes, you are not infringing yourself, but you are helping someone else infringe. For example, you are Amazon, or you are eBay, or you are all these platforms. And you see in this platform that someone trades goods that are violating someone else's copyright. And still you're not doing anything about it. You go to Amazon and you see all these counterfeit goods. And isn't it logical that we assume that Amazon should have a responsibility for it? You cannot play ignorant and as if you didn't know that someone is trading counterfeit goods in your platform. This would be secondary infringement. This would be intermediary liability, which is more common in the field of trademark, which is why in the field of trademark, our case study is going to focus. Spoiler alert. Now, going to primary infringement, that in the context of copyright is the most relevant one. What do I have to prove as the owner of the copyright to show that someone infringed my copyright? You have to prove, guys, 4 things. Again, going to my handout. First thing that I have to show, obviously, to have standing, is that I am the owner of the copyright. The exercises we discussed already when it comes to ownership, regardless of the test you want to apply, you need to be the owner or the co-ownership, like especially when you have like books and stuff that are written by many people, all of them are owning it, okay? They are co-owners, like a joint ownership. This is the first thing you need to prove. Second thing is, you have to show that the work that you allege copies your own work is substantially similar to yours. Because if it's not similar to yours, it's not infringing. Now, do I have to prove that the other person that infringes my copyright had intention to do so? Do I have to prove that the alleged infringer wanted to infringe my copyright? No, guys. For primary infringement, intention is not important. You can have someone with the best intentions. If they copy you, they infringe. Okay? So even if they didn't want to copy you, the mere fact, the objective fact that they copied your work is enough to substantiate a potential infringement claim. So first you prove you're the owner of the work. Second, you prove that the work, the allegedly infringing work, is substantially similar to yours. Because if it's not similar, it's not infringing, you understand that. It has to be very similar to yours. Third thing you prove is that the infringer had access to your work. So there was an opportunity for that person to copy your work. For example, I write a song. I am the composer of a song. And then after a while, after 1 year, after my song has been in the radios, I listen to a song that I think is very similar to mine. Now, copyright infringement when it comes to songs is a little bit more complex because you have to prove many things and many things are in the public domain. So it's not so easy to prove infringement for songs as you may think. But I have to show other than the fact that I'm the owner, other than the fact that this song sounds very similar to mine, I also have to prove that this person probably had access, had an opportunity. There was a causal connection between that person and my work. In my case, this wouldn't be so difficult because if this person, if my song plays for a whole year on the radios, you assume that there was access to the work by just listening to the radio or on YouTube or on Spotify or whenever. So access wouldn't be so problematic in my case, but you have to show that the person could have access to your work. Otherwise, if you keep your work in your drawer, then it becomes very difficult for you to prove that the other person had access to it. Okay? And the final thing that you have to prove to show infringement is what exactly is it that this person has done wrong? Because yes, there is a very straightforward scenario that Cheryl took my book and started distributing the book to you. Yes, obviously this is wrong. Is this the only thing that me as the owner, I can forbid people go to see this beautiful drawing that I have done in the handout? You will see that from a series of acts. These acts are essentially 5. First one, reproduction. Reproduction is just a fancy way to say copying. You cannot take my work and copy it literally. This is copyright infringement. Or, in my example before, what Cheryl was doing, distribution. Distribution, again, very simply, when you issue copies to the public. Third scenario, same case, but you do that online. This is, in copyright language, communication to the public. So when you upload things, if you go at the end of the handout where I have the case studies, you will see that in every single picture that I have, you can click on it. I have a hyperlink where you can click on the picture and go to some information that I think are useful when it comes to all the case studies that I've chosen for you, from the monkey to the paintings to anything. Now, imagine if I had this hyperlink and I sent you to a place where you would have copyrighted material. I would say I'm not infringing any copyright because they're not directly in my handout. I just have a hyperlink that you have to click and go to the material that might violate copyright. This is not an example of theory. You have so many cases on this issue. Is the person liable for the hyperlinking of copyright infringing material? So, reproduction, distribution, communication to the public, translation, adaptation. Adaptation simply means you take a book and you make a movie out of it, or you take a TV show and you make a theater play out of it. This is adaptation. All these things, as the owner of the copyright, you can prohibit the infringer from doing. Okay, because these are your exclusive rights. These are the exclusive rights of the owner. Only the owner can do these things with his work. Nobody else. Obviously, without authorization. If you have authorized them, it's fine. They can do anything they want, anything you have allowed them to do. If you have not given authorization, if you have not given permission, only you can do these things: reproduction, distribution, communication to the public, translation, adaptation. Only the owner can do these things, which is why they're called exclusive rights, exclusive economic rights. Okay, because you can benefit from your work that way and take money out of it. So if you prove all this, that you are the owner, that the two works are substantially similar, that the infringer had access to your work, that the infringer violated one of the exclusive rights that you only should have. If you prove all this, there is infringement, there is copyright infringement. Now, is the story over? No, not necessarily. Because the last hope of the infringer is to say that, yes, there is infringement. In principle, there is an infringement, but I'm not liable for it. This is what we call defenses, exceptions to infringement. This is in copyright language when we talk about fair use. Fair use and any type of defense, because defenses are very important in all IP rights, but in copyright defenses are pretty easy because it's just one, it's just fair use. Defenses allow you to say that, yes, I understand that I have infringed, but I'm not liable for it. I won't pay for it because I have a valid reason that I'm infringing. This valid reason, this defense, is fair use. Now, what is fair use? Because it also sounds a little bit technical. Fair use is very simply a defense where you say, yes, I copied your work, but I copied your work because I wanted to use it, let's say, for educational purposes. Or I wanted to use it to write a paper to criticize you. Shouldn't I be able to criticize you? Yes, but in my criticism, obviously, I will have some copyrighted material inside. Am I liable for it? No, because criticism is one of the amounts, is one of the indicators of fair use. So fair use is just an umbrella term in order to show that, yes, I infringed, but I'm not going to pay you because I had a right, I had a reason for which I infringed. Now, how do you show that your use was fair? Because if Cheryl takes my whole work and uses it as hers, and you understand it doesn't sound right that she can hide behind fair use if she steals all my work. So to qualify this and to make sure that fair use is not overused or is not abused by parties, we have to show 4 things in order to prove fair use. The first one is, why did we use? What is the purpose that we use the work? Why did you copy someone else's work? Did you have a valid reason? Did you do it to create, let's say, a parody or to make a cover on YouTube, a cover of a song? What was the reason why you copied the other person's work? This is one. Second is, what is the nature of the copyrighted work, of the work that allegedly got copied? Because the more original the work, and you understand, the less likely it should be fair use. If the work is very original, fair use usually will not work. Fair use will work mostly in things that are a little bit more common. Third factor. How much of the work did you copy? Did you copy only as much as you needed for you to do your thing, to do your parody or to do your criticism? Or you took, let's say, the whole song because you wanted to make fun of it? Because if you took the whole song, and this is not proportionate, you didn't have to take the whole song for you to do your parody. So you also have to show a more quantitative thing. How much of the song did you copy? You only should copy as much as you need. Otherwise, it's not fair use anymore. Fourth one, and more important, how much did your infringing work affect the market, the relevant market? So, did the owner of the original work lose part of their market share because of your infringing work? Because if you made the market smaller for the original work, this likely will not be fair use anymore. Your fair use is not fair when it interferes with someone else's market. When I lose the proceeds, the money that I was making from my original work because of what you did, because of what you stole from me, this is not fair use anymore. You shouldn't be interfering in my market. Okay? So when you can prove all of these things, like what is the purpose of your copying, what is the nature of the copyrighted work, how much did you copy, and how substantive was the part that you copied, what was the effect on the relevant market. If you are able to prove all this, then it's likely that you will get a fair use exemption. And bear in mind, fair use, guys, because it's an argument that comes to play in the case studies we're going to see now. Cheryl, do you want to translate something?
Oke, gini kelas bahwa saya pernah jelasin soal fair use ini, bahwa fair use ini memang sering dipergunakan sebagai defense di dunia edukasi, di dunia pendidikan. Nah, jadi tadi dia ngejelasin cara membuktikan fair use itu pertama adalah tujuan menggunakan ciptaan tersebut. Ya. Yang kedua, nature of the copyright. Yang ketiga, seberapa banyak sih kamu mengcopy? Nah, saya pernah jelasin, ingat nggak, bahwa Australia itu menentukan bahwa 10% dari hasil kerja yang bisa digunakan sebagai pembelaan fair use. Kalau lebih dari 10%, maka itu sudah melanggar. Saya masih ingat ya, yang kelas saya yang grup A mungkin. Terus yang terakhir, Prof. Nikolaos menjelaskan seberapa banyak yang kita langgar ini, hasil perbuatan yang kita langgar ini mempengaruhi market. Jadi misalnya kita membuat sesuatu ciptaan terus ternyata mempengaruhi market atau pasar dari si pencipta asli. Nah, itu terbuktilah bahwa kita udah nggak fair use lagi gitu. Seperti itu ya. Yeah, Prof. Nikolaos, I already translated. Yeah.
Perfect. So, guys, this is the equation that I want you to have in mind for all the case studies that we're going to see. Okay, because the case studies that I chose for you today are a little bit more peculiar because most of them are pending in the courts. So this is very good for us to decide how should this case be decided. Should we give protection to AI? Should ChatGPT be considered the owner of these works? Can ChatGPT hide behind fair use in order to shield itself from any potential liability, civil liability? These are the things that I would like you to have in mind. So have all this equation in mind, work. You have to show that you have a work, that you have an expression that is not just an idea, because an idea wouldn't be enough. You have to show that your work is one of the works that we saw, either authorial or entrepreneurial. You have to show that your work is original, because if it's not original, it won't get protected. But I told you, original is not that high threshold as it might sound, because original does not mean new. Original does not mean novel. Original means mostly that it comes from you. It's a product of the author's creative choices. Then you have to prove that you are the owner, that you own this copyright, with the small caveat that I told you about the employer scenario. Then you have to prove infringement. Infringement, I told you what you need to show. Mostly for primary infringement, after you show you are the owner, you have to show substantive similarity between the two works. You have to show the infringer had access to your work. And you have to show that the infringer violated one of your exclusive rights. Exclusive rights being the ones we discussed: reproduction, distribution, communication to the public, translation, and adaptation. If you prove all this, and if you can disprove that the other side has a fair use defense, because then you are lost if the other side has, then your game is over. Then you won your infringement allegation, and you probably will get lots of money, because IP infringement is a tort claim. Don't think about game. IP infringement is a tort. So see it as you would see any other tort. Now, with all that in mind, let's start seeing the case studies that I have chosen for you guys today. Now, you can go to your handout, because everything will be much more helpful if you can see the pictures that I have there. I mean, okay, not necessarily, but it will help you visualize things. So in your handout, as I told you, you can click in any of these pictures, will direct you to a website that will have some information that I think are interesting when it comes to these cases. I have this in every single case, or like a blog spot, an article, a video, things that it will be pretty simple for you to read after the class, if you want to go deeper, of course. Now, let's start with the general problem that we have here, because the logic in all of the case studies is similar. You have an author who is not human anymore. You have an author that is, simplest scenario, our first case studies, an animal, or more complicated, but we have to talk about it because this is copyright law today. AI. What happens when AI creates the work? So, starting from the simplest scenario. The simplest scenario is this monkey case. I'm not sure if you are aware of it, but because it happened in Indonesia, the incident, not the lawsuit was in the US, but this was in a national park in Indonesia. A guy called Slater, but we'll call him the guy, doesn't matter, goes to the national park there in Indonesia. In what city, don't ask me, I don't remember. And puts all his photograph, all the equipment, sits there, spends some time meeting the animals, staying with them. And at some point, you have this monkey that you see in the picture that goes and presses the button and takes a selfie. This is the actual selfie that you can see in your handout. The monkey selfie. Now, from this very innocent looking selfie started two huge legal battles. The first battle was because after that, the guy went back, Mr. Slater went back to the US, to the United States, and he realized that a huge media house published the picture without giving him any credit. He sues for copyright infringement, saying that yes, okay, the monkey took the selfie, but it's my photograph. He used my machine to take it. He used my camera. This is one dispute. Now, the dispute goes to the courts. The judges are all wondering, like, what is it exactly that we're discussing here? And the defendant, which, by the way, is the media house, the mother company of Wikipedia. So you understand how much money we're talking about here. And Wikipedia said, yes, I can use the monkey selfie. What's wrong with that? I'm not infringing anyone's copyright because, in my opinion, there is not even copyright here. The monkey took the selfie. And we know that the conventional wisdom when it comes to copyright is that it only vests in humans. Non-humans, animals in this scenario cannot have copyright. How is it possible? This was one claim. Then the guy comes, he counter-argues. He says, yes, the monkey took the selfie, but I sat there for a whole week to be more familiar with the animals. All the equipment was mine. I created all this environment for this picture to happen. So, in my opinion, I own this copyright. Now, when it comes to the US, you will see the same logic, even in the AI case that I have the US case below. They will never give copyright to non-humans. For them, copyright is something that only humans can have. No animals can have it, no AI can have it. They have a very rigid position for whatever reason, even though copyright in the US is generally quite liberal in how it is conceived, but only when it comes to humans. So the court is very clear. We cannot give copyright to the animal. We cannot give copyright to you because this was not enough. This was not original enough what you did for this to be an artistic work. It is an artistic work, but it's not yours. It's not the animals also. So nobody can sue here. So he lost. At the same time, because I told you this is not the only dispute with this picture, there is an organization in the US called PETA. PETA is like the protection of animals, wildlife, and stuff. When this guy started selling this picture as part of a magazine, they sued him. And they said, how can you sue that? This is not your picture to sell. If anything, this is the monkey's. So, as PETA, representing the monkey, because the monkey obviously cannot represent itself, we ask you either to stop using the picture or to continue using it and give us the proceeds, the money from commercializing it. Now, this case sadly did not go to the court in the end because it was settled. But how it was settled is the guy said that, okay, I will keep using the picture because in my opinion it's still mine. But what I can do is give you 25% of the profits so that you use it for the animals there in Indonesia in this national park, this macaca, or however these monkeys are called. This is the first set of cases. Now, when it comes to AI, which is our second set of cases, you will realize that the problems are actually pretty similar and why AI generated work is so problematic in the field of copyright. So I have divided the cases in two parts. The first one is what I have called the next Rembrandt in your handout. So check this picture that I have there for you. By the way, Rembrandt, if you're not aware, Rembrandt is like a very famous painter, okay? Dutch painter, let's say 300-400 years ago, okay? So, which is also important, Rembrandt used to live in a time where copyright did not exist. Now, what did people do here is they made an AI, they put all the paintings, like 300 paintings that were found from Rembrandt, and they said to the AI, please take all these paintings and make a new one that has the same style that Rembrandt was using to create his own. So the picture you see in your screens in the handout, the next Rembrandt, is not by Rembrandt, is what the AI had in mind, collaborating all the techniques and all the methods that Rembrandt was using to create something new. Then it created this, they put it in a 3D printer, and the result was an actual painting, the next Rembrandt, that was not even made by Rembrandt, and was made by AI. Now, this is not a case that went to the courts, because you understand Rembrandt doesn't have copyright, because he lived in a time, sadly enough, that there was no copyright for him, so even his successors cannot sue. So this case couldn't go to the courts. Nonetheless, if this case went to the courts, is there a valid claim if there was a copyright in the original? Is there a valid claim against the person that created this? Because you cannot sue the AI, I'm sure you understand that. But you can sue the developer who made this AI or who gave the commands, because you must be aware how AI works. You give what we call a prompt. A prompt is like a written command. Like, take these paintings of Rembrandt and make me a new one using the same philosophy or the same method or the same technique that Rembrandt was using, which is how the AI came up with this thing that you see in your handout. Is this copyright infringement? Is my question. Again, this is a question that didn't reach the court, but it only didn't reach the court because there was no copyright in the original works. If there was, do you think that the AI generated work would be infringing based on what we discussed? I would like to hear you guys. Don't be shy.
Oke, ada yang mau menanggapi? Jadi gini tadi, Prof. Nikolaos menjelaskan tentang AI generated work ini bahwa yang bisa dapat copyright itu manusia, ya, human. Jadi animal tadi yang pertama itu yang foto oleh yang monyet tadi yang capture it, selfie monyet itu nggak bisa dapat AI, ya, karena yang bisa jadi creator copyright itu hanya manusia, human. Jadi no AI or no animal, ya. Terus yang kedua itu Rembrandt itu jadi kan si Rembrandt ini udah terkenal beberapa ratus tahun yang lalu. Belum ada tuh copyright. Nah, sekarang dengan AI, ciri-ciri khas si Rembrandt itu diolah untuk menjadi karya. Nah, itu melanggar nggak? Itu yang ditanya sama si Prof. Nikolaos. Kalau menurut kalian gimana? Coba pakai bahasa Indonesia ya, nanti saya yang translate ke Prof. Nikolaos. Ada yang mau menanggapi mungkin?
Yeah, that can also work. I mean, if I understood what you told them.
I think they're just shy because maybe not sure about their English, so just quiet. But I think
but it's
they
fine.
have opinion.
They can say in Indonesian.
Yeah,
Also.
you just can say in Indonesia, so I will translate it for Prof. Nikolaos. Oh yeah, Samuel. Yeah, Samuel.
Izin menyampaikan, mungkin boleh pakai bahasa Inggris juga Bu sekalian.
Oh, ya silakan.
Maybe it's in my opinion, maybe it can be punished because I think it's already in hundreds of years. Like it seems like the AI generated like classical music, like Beethoven one or Schubert one, and I think there is no one who have the authority to have the IP, the copyright one.
Yeah, but that's true. But if it was, I want us to do the whole exercise. It cannot be so simple to say, yes, there is no copyright anymore, and even if there was, it's expired. Yeah, this is obviously true. But if there was copyright that was still valid at the time, do you think that this would be infringing?
I think yes, maybe in this time.
Hmm. Why though? Based on what we discussed on infringement and the conditions for infringement, do we have actual copying here? Because here we just have the AI using paintings more as an inspiration to create something new. It's not really that, it resembles, like you could see it and say, oh, this looks like a Rembrandt painting. But is this enough to qualify as copyright infringement?
Oh yeah, sorry for that. I think you are correct because the AI only generated not the original one. So the I think in uh, the AI picture one is not as same as the original. Maybe the Rembrandt, the
Yeah,
original one.
I would also start like that. That yes, it's obvious that you got inspired by the paintings of Rembrandt, but you didn't copy them. Yeah, there's no literal copying here, which would make the infringement pretty obvious. And what do we know about inspiration? Yes, okay, it's just an idea. Yes, you can copy the idea. It's the expression that you cannot copy. It's this idea expression dichotomy that we kept discussing in the beginning. So, yes, in my opinion, this wouldn't be infringing. Now, the second problem arising from there would be if someone copies the AI generated work, could the AI or whoever was the owner sue? Because you understand the AI, not very difficult to be considered an owner. And we saw how the US courts are not accepting that. The owner can only be the author of the work, can only be human. The same logic they apply to animals, the same logic they apply to AI. We cannot have a ownership over AI because the AI cannot have creative choices that we need. Yes, the originality standard is very low, but it exists. We need some level of creative choices. We need some level of expression. This we don't have. Now, if someone should, like, if the developer, let's say, of the AI, the developer of ChatGPT, this open AI company, created this new Rembrandt and sued a magazine that posted it, let's say it went to the court, and let's say again, for the sake of argument, OpenAI would have standing. The court would have jurisdiction to decide. Now, in terms of substance, is there really infringement here? It's a very open issue. Now, going to something that is actually talked in the court, so we have a little bit more tangible elements to talk about. Go back to your handout. The case that I want us to focus are two. The two ones on the right, one about ChatGPT, obviously the elephant in the room, and the one on the right, this girl, this like pretty girl that looks a little bit like anime. These are the two cases that I want us to discuss, and I swear I will. After that, I will leave you because I know I have bombarded you with information. So let's start with the girl. Now, what this girl is basically how have the Chinese courts treated the matter. And you would ask me, but why would we care about Chinese courts? And I would say you are right. Nonetheless, since we share the one extreme, which is the US position, have in mind that the other extreme is the Chinese position. The Chinese position give copyright to AI like no tomorrow, guys. So it's exactly the opposite, like the US. The US will never give copyright to AI. The Chinese courts almost always will do. So what happened in this case with this girl picture? A person went to the AI platform, think of ChatGPT, but it wasn't ChatGPT, but think of that because it's the most well known, and said, I want you to make me a picture of a girl. This girl should have this characteristic. The girl should look at the camera. The girl should be pretty with black long hair, and things like that. It gave all the commands. Now, the AI made the picture, as you know AIs do now, like usually if you have a subscription, and the person started using it. Now, after that, the person said under the picture, it is AI generated work. The person never claimed that he was the one who made this drawing because it looks like a drawing. It even could be a picture. If you don't look very careful, it could be even a real picture. So people start copying it, thinking that, okay, it's AI generated work, so it's in the public domain, everyone can use it. The developer of the AI sues in the name of the AI and says, what is this? Copyright infringement. This is AI generated work. My AI made it. It's not in the public domain. I want money. I want compensation. The case goes to the courts, and this whole thing triggered all this tendency of Chinese courts to give copyright to AI works. And the Chinese court, if you expect me to tell you like some very elaborate legal argument, they didn't do that. They approached the issue logically. And they said, we live in a time that this AI generated work will be more and more and more common. So if we end up not giving copyright to these works, it will be like we encourage copying. Is this something that we do? No, copyright is the exact opposite of that. We give this whole strong monopoly, we give exclusivity because we want to reduce copying. Not everything should be in the public domain. This was their starting point. Then they try to make an analogy. And they say, think of your smartphone, think of like you have this phone. And you take pictures. At this point, smartphones have become so sophisticated and so artistic in themselves that the human input becomes less and less and less and less. But will anybody ever say that if I take a picture with my phone, this will not be an artistic work and copyright protected, my copyright? I guess no. This would be an artistic work. Then what is the difference if I say to an AI, I want you to create a picture like that? This is what the court said. And they said if we give copyright protection as an artistic work to the picture that you take from your phone, and then I want to give copyright protection from the work that the AI created. Now, is this true? In my opinion, no. Because it's not the same. The AI will not create the work. The AI will take the work from a huge black box of millions of pictures and just based on your command, based on your prompt, it will just take this picture and give it to you. So this for me is problematic, not only in the level of idea expression dichotomy, but also to the level of, then where is the originality there? Where is the input? I don't say you need a human input. I agree with the Chinese people that the input can be non-human. But here there seems to be no input. So I am not so sure that even though commercially, logically, it sounds right, there is merit to what the Chinese judges say. Legally, I'm not so sure. So if you know all this copyright story from start to finish, like from copyright existence, subsistence. Do we have a work? Is it original? Who owns it? Do we have infringement? Do we have a defense? If you know all this, you can find loopholes in each and every one. Let's say continuing the equation and going to ChatGPT, and I swear this is the last thing that I'll tell you. So the facts here are very simple. This is also a pending case in the courts, and I'm not sure it will go to the courts. I have a feeling it will be settled, as most of these cases are. New York Times are suing ChatGPT, saying ChatGPT took all our material from our magazine, from the New York Times, and it uses our material two ways. One, to train its model and make it, be a little bit more knowledgeable when it comes to the prompts, to the commands that it gets. And second, by keeping a repository from all this information. Like this is like a library that ChatGPT has, a library of copyrighted material though. And New York Times is like, but I'm losing money because of you. And why do we focus there? Because remember, obviously ChatGPT said fair use, fair use, fair use, fair use. But is this really fair use? Remember, one of the parameters, the last parameter on fair use, is how do you influence the market of the original? And the New York Times says, obviously you influence my market. All these people that had subscription on New York Times, now they don't have to. They just ask ChatGPT. What does this article of New York Times say? ChatGPT will tell you. Isn't the New York Times losing clientele because of that? I mean, this is my take. I don't want to influence you in any event. I just want you to know the whole exercise, because for me, this is an exercise. You can, theorize it all you want, but at the end of the day, it's like 1, 2, 3, 4, 5 that you have to prove. And ChatGPT very conveniently skips all the exercise and goes to fair use. And fair use, maybe you can use it more convincingly when it comes to the first argument of New York Times, that yes, you use it to train your model. Yes, but you didn't only use it for that. You keep a repository, and every time someone asks you, what does this article say? ChatGPT will tell you. Maybe not verbatim, maybe not copy-paste, but it will tell you what is written in the article. And then why would I subscribe to New York Times? So even though, again, I tell you a disclaimer, I don't want to influence you, I think New York Times is right here. And not because I care so much about New York Times, but because, guys, this may potentially open like the Pandora's box of legal issues, legal and commercial issues when it comes to this issue, to these matters. This is all I had to say. And sorry, I know that I took a little bit more time, but I hope you found it interesting, guys.
Yeah, Prof. Thank you, Prof. Voutyrakos. That's such an interesting and informative presentation, Prof. So maybe we can jump to the Q&A session, Prof. Is it okay?
Yes, I'm done in terms of what I wanted to say.
Maybe participant want to ask question directly to Prof. Voutyrakos, or you can chat. Okay. Linda Ariska, you can ask directly to Prof. Voutyrakos.
Okay, thank you for the opportunity. Firstly, let me introduce myself. My name is Linda Ariska. I'm from Faculty of Law, University of North Sumatra. And firstly, I would like to say that I'm proud to meet you, Prof, because your explanation is very useful for us. And I want to ask a question, but I'm very sorry if my question is not good or my English is not good. So in Indonesia, there are so many cases that the original author offers the skill to other peoples that they need to write a book such as scientific articles or journal or textbook. But my name, for example, I am as original author and my name is not included of the book. But I can still get the royalty from the customer that the other peoples need my services to write a book. So does this action violate copyright if the original author is willing to have his writing acknowledged by someone else? Thank you.
Okay, Linda, thanks for your question. I'll answer one by one if that's okay. Yeah, so Linda, the issue here is twofold on what you ask. At least that's my take, because obviously your issue is also a little bit fact specific. So, in principle, if you are not credited for your work, and if you can prove that you contributed to it, so this is not such a legal problem anymore; it's more of a factual problem. But if you can prove your contribution, either you can claim joint authorship, so you can claim to be mentioned there, or you can claim just the royalties if you don't care of you being mentioned. Now, a problem that you would have in such a scenario of proving it is, first of all, why weren't you included as an author in the first place if you contributed there? This I didn't get. Why wasn't your name there even though you contributed to the work? This, if you could explain to me a little bit more.
Prof, pardon me. Sometimes I don't know how to say it, but this is the side in education in Indonesia. So sometimes students being shadow writer for the lecturer. Okay. Yeah, maybe you can understand. Yeah, maybe Linda asking about that. You know.
Yes, I mean it is everywhere. It's even in India it happens a lot. But this is, in my opinion, not so much an IP issue. It's more of a contract issue. It's more of what have you agreed with the party you're working with. Have you started with the assumption that you both of you will work together and only one will be credited? Because if yes, then you cannot go in hindsight and say very conveniently, oh, now where is my money? Also, for many of the, like if it's just a paper, there will be also no money. But I guess if it is a book or something that holds some strong royalties, for example, if I want to write an IP textbook in Indonesia, yes, I know all the students in Indonesia are going to use it. Probably this will give me lots of money. For that, it's likely I will use many students to help me draft. Probably, ideally, not undergraduate students, but I mean, I'm sure that many faculties use, but usually we use master students and above for this, for actual drafting, unless it's only for research. No, if you only do research, Linda, I agree that it's right for you not to be mentioned. Like the most classic way is to put a footnote in the beginning and say, I thank this person for the research assistantship. Like this is how I do it. So if they have agreed with you to have a share in the royalties, then that's fine. But this is not an IP issue anymore. This is a contract law issue. This boils down to your relationship with your counterparty. I hope I answered.
Thank you, Prof.
Okay, thank you, Linda. There is another question? No. Okay, I think maybe there is. Yeah, Samuel.
Okay, makasih Bu. Thank you, sir. My name is Samuel. I'm from Faculty of Law, Sumatera Utara, and I'm just asking about your explanation. In your explanation, you said that IP law is not globally same, and you have to follow the local regulation. And my question is how about the famous luxury brand like Gucci or Yves Saint Laurent? Are they will also have to follow the local one, or just follow the international one like the Madrid Protocol? And the second one, maybe in the future, maybe the local brand like Indonesia, or for the example, like in France, you know, the champagnes is originally from France and also known globally now. And are they same like the luxury one? Because I see from the court decision in Indonesia, some use the local one, local regulation, some also use the Madrid Protocol.
Yeah. Okay. This is not copyright related, but still it's interesting because it has to do with more of this global versus territorial debate that we have. And because it's a very common misconception. Because you see all these TRIPS agreement burn copyrights, you don't. Still, if I have a trademark in Greece, I will only get protection in Greece, no matter how many international conventions I have signed. If I want protection in Indonesia, registration, which will be circulated in domestic offices. So the only thing that makes your life easier is you make one registration. Protection they're going to give you is domestic. So they only facilitate the registration process, not the protection. The protection is still domestic. Okay, GI. Yeah, so GI, sorry?
Yeah, I mean the local one, maybe.
Yes. So even if you have a GI, the protection will be domestic. The issue is that because with GIs are geographical indications, like, some goods that are produced in specific regions. We're not going to touch on GIs in our lectures, but the logic of GIs is a trademark logic. You want to protect the source of origin. So, yes, you cannot produce a sparkling wine and call it a champagne, because you can only call it a champagne if it comes from this specific region in France, which is called champagne. But you can use the same technique and make the same thing. You will not violate any IP, but you cannot call it a champagne, because champagne is protected under GI laws, under geographical indication laws. But you can use all the methods and the techniques that they use to make a champagne, but you have to call it like sparkling wine or something like that, or, Prosecco or something like that. You cannot call it champagne in such case. Okay?
Yes.
Okay, thank you, Samuel. There is another question. Prof, I think maybe that's enough for today. Thank you so much, Prof, for wonderful and insightful presentation, Prof. We hope all participants enjoy all this our discussion today. Yeah. I would like to invite all the participants to turn on your camera. We will have some documentation and also a virtual group photo shoot. Please turn on your camera. Okay. The first one. The second screen. The third screen. And the fourth screen. Okay. Prof, thank you so much for today, Prof. So happy to have you. Have a good day, class, and Prof. Voutyrakos. Assalamualaikum warahmatullahi wabarakatuh. Bye-bye.
Bye, guys. Thank you so much. And guys,
Yeah,
don't be
thank you,
shy to
Prof.
talk, okay?
Yeah, Prof.
This is not a language exam, okay? Even for me, English is not my first language. Love your accent, guys. Okay?
Yeah. Thank you,
I'll see
Prof.
you next week with patents,
Yeah.
guys.
See you on patent class. Bye,
Bye.
Prof. Bye. Terima kasih ya semua.